In this video, I'm going to be looking at precedent in the Supreme Court and the Court of Appeal, and this includes information on the practice statement. Starting off with precedent in the Supreme Court. Before 1898, the House of Lords had the right to overrule past decisions. The case of London Street Tramways versus London County Council changed the law so that the House of Lords would, from then on, follow its own past decisions for more certainty in the law. This continued until 1966, when the House of Lords issued the practice statement, changing the rules set out in the Tramways case. In 2009, the House of Lords was renamed the Supreme Court. The practice statement is a document that sets out scenarios where the Supreme Court doesn't have to follow precedent. This allowed the House of Lords to change the law where it believed that the outcome of a previous case was wrong. BRB versus Harrington used the practice statement to overrule Addy versus Dumbreck in 1972. The statement is seldom used in criminal law, as certainty is essential. And then looking at precedent in the Court of Appeal. The Court of Appeal has to follow decisions of the Supreme Court, even if they think it was wrong. The Court of Appeal has to follow other Court of Appeal decisions, like in Davis versus Johnson. However, decisions by one division will not bind to other divisions. Young versus Bristol Aeroplane Company set out 3 situations where the Court of Appeal doesn't have to follow previous decisions. If there are conflicting outcomes in Court of Appeal cases that have come before, where a previous Court of Appeal case has been overruled by the Supreme Court, and where a previous Court of Appeal case was made in error by not following law. The Court of Appeal should ignore previous decisions in criminal cases where people's liberty is at stake, like in R versus Gould. Here's what a question might look like on this topic. Hopefully this video is helpful. Have a nice day.